Hello and welcome to my channel. Today we'll discuss one of the most polarized topics since the formation of independent India. It is UCC or Uniform Civil Code. First, let's take a look at the background and the current legal provisions in place. Article 25 of the Constitution of India guarantees the right to freely practice religion. This is a fundamental right granted to every citizen of India. And derived from this right are the personal laws, where every citizen of India is allowed to follow customs based on his or her religion. These customs and practices can be applied to the areas of marriage, divorce, succession, adoption, guardianship, and maintenance. So we have Islamic law for Muslims, Christian law that applies to Christians, and Hindu law or Hindu code that applies to Hindus. Now, what is Hindu code? Hindus have varying practices and customs. For example, some practice polygamy, that is, men having two wives. Marrying cousins was okay in some parts of India, and women did not have an absolute right to property. This means where a husband died, she was only a custodian of the property until her son became the major. So, all these practices needed to be put into writing with clarity as to what is allowed, what is not allowed, who can be exempted, how to determine if something is valid, procedures, punishments, all these things. This is called codification. The Hindu Code, passed in 1956 by the Nehru government, comprises of 4 acts. So now we have the Islamic law, the Christian law, the Hindu Code for Hindus, and included in the definition of Hindus are Buddhists, Jains, Parsis, and Sikhs. And we also have some other specific laws applicable to Jews, Parsis, etc. There are several disadvantages of breaking law like this based on one's religion. Lack of uniformity promotes inequality and discrimination. Treating citizens of the same country based on one's religion is indeed a form of discrimination. For example, child marriages are considered a crime under the Prohibition of Child Marriage Act 2006. But since marriage is a part of the personal law, Muslims are exempted from the act and they are allowed to enter into child marriages under the Islamic law. This is discrimination from two perspectives. The first is that we have created multitude of laws to protect female children from early marriages. But through these exemptions, we are stripping off Muslim female children from enjoying these protections. And the second is that what is a punishable crime for persons born into one religion is a permissible act for a person born into another religion. And polygamy, just like child marriage, is other example of such discrimination. And the second disadvantage is that it promotes gender disparity. Since religions are based on age-old customs and traditions that root back to when women were treated as mere property, laws that are purely based on religion do not treat women as equals. For example, a Muslim daughter inherits only half of her brother's share. A Hindu or a Christian in the same position would inherit equal share as her male counterpart. The third disadvantage is that it promotes customs that have no place in modern society. Personal laws take away absolute freedoms and impose religious and social burden on the individuals. For example, the law under Section 9 of the Hindu Marriage Act 1955 or Section 22 of the Special Marriage Act 1954, the restitution of conjugal rights, can subject spouses to have forced sexual relations. Of course, the court is staunch against calling this mere sexual relation and it uses many fancy words such as marital duties, cohabitation, and whatnot. But underneath all these fancy words and layers is sex against will. One of the courts even called this the grossest violation of human dignity and privacy. So, dower, polygamy are other examples of customs under the personal laws that should have no place in the modern society. And the fourth disadvantage is that it strips away the rigidity in law. Since there is no codification or statute, law is at the mercy of the interpretation of the court. Today, our country of 1.2 billion people lack a proper law on maintenance. One has to refer the case of Muhammad Ahmed Khan versus Shahbanu Begum or some other decade-old case to mandate maintenance. And the fifth disadvantage is the interference of state into personal matters. By no means does the definition of freedom of religion or secularism include interference of state into personal matters. However, today the laws such as Section 7 of the Hindu Marriage Act 1955 heavily interfere with customs. For example, where it comes to the question of the validity of marriage, the courts look into whether a tali or Mangal Sutra has been tied, whether the couple went through Saptapadi, or whether they have exchanged rings, or whether they have written Nikah Nama. Instead of solely basing the validity of marriages on registration records, it heavily relies on ceremonies and customs. The courts have been continuously promoting the idea of in the best interest of the child, which seems more fair and just than the natural guardian of a minor. Such changes in the language of the law are missing in the personal laws today. And the seventh disadvantage is today multiple iterations of the same law have to be made in order to be applicable under different religions. Sometimes these iterations may take decades to pass. For example, the amendment to Section 6 of the Hindu Succession Act 1956 that enables a daughter to become a co-partner came to effect in 1986 for Hindu women in Andhra Pradesh and in 2005 for Hindu women across all India. And 37 years later, it is still pending for the women falling under the Islamic law. The personal law situation has created a tangled and a complex law. One of the major problems of today's personal laws is that there is innumerable and unnecessary questions of law consuming valuable time of the courts. For example, what could be a simple question of validity of marriage spawns into questions like, is the marriage valid when a Christian pretending to be a Hindu marries under the Hindu customs? One may refer to the case of Gulipalli Saurya Raj versus Bandaru Pavani. Or question like, is the marriage valid when a Muslim marries a Hindu under the Hindu customs and marriage registered under the Special Marriage Act 1954? Tangled and unnecessary laws confuse common man, advocates, and judges alike. Simplified law saves time and valuable resources. Therefore, without an iota of doubt, having a uniform civil code is essential. UCC brings uniformity to law, and law shall be applied uniformly to all citizens despite their religion, race, or custom. UCC promotes gender equality. Having UCC will bring fair succession, maintenance, and divorce procedures that treat women equally with men. Codification brings rigidity to law, as we discussed before. It saves valuable time of the courts, as the courts can judge based on codified statutes instead of deriving interpretations based on customs. UCC removes interference of the state into personal and religious matters, and codification brings clear-cut interpretation of law. No need for multiple iterations to apply law to each and every religion. Law once made will apply to the entire country. Of course, this is subject to exceptions. It simplifies matters and it removes unnecessary questions of law pertaining to religious custom. The next question arises. We have seen that the personal laws are based on religion, which are covered under Fundamental Rights, Article 25. Can a person be stripped of his fundamental rights? Yes. The first point is fundamental rights are not absolute. They are limited rights only. And secondly, enacting UCC will give effect to Article 44, which is a directive principle. In the landmark case of Keshavananda Bharati versus State of Kerala, it was inferred that the fundamental rights are individual rights, while the directive principles are social rights. So it makes sense for the directive principles to prevail over the individual freedoms and rights for an effective functioning of the democracy. Also, in case of UCC, the state will not completely strip off its citizens of the fundamental right to practice religion. It will only remove the state's interference into religion and religious customs. For example, a Muslim couple can still marry under the traditions professed by the Islamic law. But the state will recognize the validity of a marriage only through registration certificate or a record of registration instead of a Nikah Nama. This will be the true meaning of unbiased and secular UCC. So before we close, I would like to emphasize three things. That in order for UCC to work effectively, these are the aspects that must be considered in drafting the new UCC. The first, UCC must be purely secular in character. Second is that the UCC must be purely unbiased in nature. And the third, that UCC must not only revive uncoded laws such as the Islamic laws, but the coded laws such as the Hindu code also, in order to suit the needs of the current and future generations to come. If you have any questions, suggestions, feel free to post them in the comment section. And for more such videos, please do like and subscribe my channel. Thank you very much.